Good afternoon in Kumori-Con. Looks like it's about 3 o'clock, so I think we can go ahead and get started. We've got a full panel today. This is Law for Creatives and Weebs and Creative Weebs by me, Mallory Mallow, at Kumori-Con 2025. Before we get started, just a few disclaimers we have to cover. First, I am a lawyer, but I'm not your lawyer, and nothing in this panel is legal advice. If you have specific legal questions, you should consider speaking with a lawyer who's licensed to practice in your jurisdiction. Second, I've tried to make this panel as generally applicable as possible, but it's impossible for it to be comprehensive because law does vary significantly on a state-by-state, not to mention nation-by-nation basis. We also have limited time, so this will focus on just a couple of topics, that being contracts and copyright. Possibly there could be some others in the future. Third, this panel is current to the best of my knowledge, as of October, I should say November. But the law is constantly changing, especially in some of the areas that we're going to cover. And finally, all opinions and errors are mine alone, even though I'm sure there won't be any errors. Now, a bit about me. I've been a lawyer who is not your lawyer for over 10 years, as well as an illustrator for over 20. I've also done a number of panels, which you may have been to. Today's panel will be a bit different. What this experience has really helped me to understand is that law is important to just about everybody. Law affects everyone's lives, but especially artists, VTubers, creatives, anyone who's in business for themselves. And in addition, often there's a lack of access to quality legal information, which leads to certain misconceptions being spread around. So we are going to try to address some of those today. We're going to do a very high-level overview about a couple of legal concepts that might be relevant to creators, such as, again, copyright and contracts. We'll talk a bit about when and how to get a lawyer, things you might wish to discuss with them, and we will be taking questions at the end. So, without further ado, let's start with copyright. We'll talk about copyright formation, how do you get copyright register one, talk about enforcement, DMCA, fair use, questions of ownership, which arise a lot in a commission type situation, talk about licensing, public domain, abandonment, and finally, because it is the year of our Lord 2025, we'll have to talk a bit about AI. So what is a copyright anyway? Well, it's a legally protected right to do certain things that are laid out in statute, such as copying a work, preparing derivative works of that work, that is anything that follows on that work, such as sequels, fan fiction, fan work, translations, things of that nature, the right to sell or rent or so on copies of that work, the right to publicly perform, display, or play the work, depending on what type it is. One common misconception, though, is I should note copyright does not include the right to be attributed. That is not mentioned in the copyright statute. So plagiarism in the sense of misattributing someone else's work to yourself, that is unethical and wrong, but it is not copyright infringement within the statute, although the copying itself might be. And conversely, and this is important, sourcing is not a defense to copyright infringement because the copyright statute doesn't mention attribution anywhere. So if you've been on YouTube and you've seen those videos with this is, I didn't make this is copyright so-and-so, no infringement intended, that kind of thing, those unfortunately do not have any legal effect. So how do you get a copyright anyway? Well, the statute lays out the requirements for a copyright to exist, which include, first, is an original expression. But what that means is that facts are not protected, so things like maps, phone books, even if someone put a lot of work into obtaining the information itself, being factual, is not protected by copyright. Similarly, abstract ideas and concepts are not protected, only the expression thereof. So if you've ever heard someone say, well, so-and-so stole my idea, if it wasn't expressed anywhere, then that's not really a copyright issue. And finally, this is another, I think, somewhat common misconception. Single words short phrases generally do not have the level of originality required to qualify for copyright. So things like the title of a work may not be copyrighted depending on how short it is, although trademark could still apply. To be copyrighted, a work must also be a work of authorship, and implicit in the statute is that it has to be authorship by a human. Animal-produced works, like there's a case with a monkey taking a picture. Animal-produced works, AI-produced works are not eligible for copyright. And finally, to be copyrighted, the work has to be fixed in a tangible form, such as digital, written down, things of that nature. What is not required for copyright to exist is registration. We'll talk about that in a minute, but copyright automatically attaches as soon as these requirements are met. So registration is not actually a prerequisite for that. I do want to point out that more than one copyright might apply to a given work. For example, the composition of a song, the lyrics, a particular recording of that song, and a music video of that song might all be separately copyrightable and might in fact, the copyrights might in fact be owned by separate parties. That is important when, for example, you're trying to get permissions to use a song. So then you might be asking, well, if registration isn't necessary for a copyright to exist, why would you do it? Well, the answer is that registration is required as a prerequisite before bringing any kind of legal action to enforce a copyright. Furthermore, registration does allow for statutory damages, which are separate from actual damages because statutory damages do not require any showing of actual economic harm from the infringement. They are laid out by statute. They can range from as low as $200 to as high as $150,000 per violation, which, as you can imagine, can lead to some pretty large awards. There was a case, it was 2000, sometime early 2000s, where there was a person who got a $675,000 judgment just for file sharing some songs. And of course, it is not exactly a common outcome of file sharing songs. Otherwise, I imagine we'd all be in a lot of trouble. But I do have to bring it up as an example of why statutory damages do matter. So then, how do you go about registering a copyright anyway? You can do it online, at least when the government is not shut down. There is a fee, ranges from $45 to $500 depending on the type of work. You can register groups of works together for a copyright to kind of spread out some of those costs. So that's registration, and let's talk a bit about enforcement. Now, to enforce a lawsuit, to enforce a copyright, you can bring a lawsuit in civil court, which can lead to things like damages. Again, that can be actual or statutory if the copyright is registered prior to the infringement. That can include an injunction, which is a court order to do or not to do something. Criminal copyright infringement is also a possibility. The infringement is both willful, that is knowing, as well as for purposes of commercial advantage or private financial gain. And that's mostly for situations like some kind of large-scale commercial piracy operation, but it is in the statute, so they won't really know about that. But the form of copyright enforcement that you're probably the most familiar with is DMCA, that's Digital Millennium Copyright Act notifications, which you can see in the corner there. This is a three-step process where first the copyright owner or their agent submits a takedown notice to a website containing allegedly infringing content, and the website must promptly remove that content as well as notify the uploader. Why do the websites do this? Because complying with DMCA notices is actually a condition of the statutory safe harbor within the Digital Millennium Copyright Act. So websites that habitually fail to comply with DMCA takedown notices could themselves be liable for the copyright infringements of their users' uploads, which no website wants to be in that position. After a DMCA notice has been sent and the takedown has been issued, the original uploader has the opportunity to submit a counter notice if they have good faith belief that the material was not infringing. However, And this is important. By submitting a counter notice, you do consent to be sued in federal court. And after receiving the counter notification, the website must either restore the content within 10 to 14 days, or the exception is if the original sender of the DMC notice has sued the uploader. So this process ends in either the content coming back up or a lawsuit being filed, which again is not a terribly common outcome, but there is a risk that's involved whenever you send a DMCA counter notice. Now we've talked about enforcement a bit. I'd like to talk a little bit about some copyright defenses. The big one being fair use. I'm sure you've heard that term tossed around before. So let's talk a bit about how courts evaluate fair use claims. Courts use a 4-factor balancing test when evaluating whether an alleged infringement is fair use. The first one being purpose and character. Was the new use transformative, meaning to change the original to add a new meaning or message? Some examples could include parody, comment, criticism, education, things of that nature. Second is the nature of the underlying work. Is it a factual or fictional work? If you remember a couple slides ago, facts are not protected by copyright, meaning that largely factual works like biographies already have less copyright protection to start with, so it's more likely to find fair use if the work allegedly being infringed was fact-based. Third is amount and substantiality of the infringement. Did the infringing work take more than necessary for whatever transformative purposes it may have had? Did the copy go to the heart of the work, or is it just like a little snippet that doesn't really matter? And the fourth is market harm, by which I mean, does the infringing work substitute for the original and thus decrease its sales? And the important thing here is that because fair use is a balancing test, that means that no one factor is determinative. Maybe you heard that if you're making money off it, it's never fair use. Or if you're not making money off it, then it's always fair use, which again is not how balancing tests work. The courts look to all 4 factors and try to draw a balance based on facts. This also means that it is especially important to speak with a lawyer when looking at questions of fair use, because it is so fact-dependent. So, let's go to a couple of examples. And the first one is one that's very close to my heart, that being parody.
You know it's not a hard one, you don't know Japanese. And nothing is a two, tell me something fucking weird. You may not have a clue what you're trying to say, but that will stop it from what? This is where we go. It's great name, it's greater pain. You know you really good, get it anyway. Can I wash your screen? And what's on me? He's not okay, he's not okay. So if you don't know, if you don't go, if you know you don't go, the word means we are new, so hey, watch out here.
I wonder who that is. Anyway, so parody is work that seeks to comment on or critique earlier work, which the courts have found is both transformative as well as socially beneficial. The courts don't want to be in a position of shutting down criticism of other people's works. So, in the case that I'm referring to, Campbell v. Aiken Rose, it actually was a case about a parody song, not this one. But for the purposes of that test, parody, because of its commentary and critique nature, does meet the first factor of being a transformative use. As for market harm, parodies don't really substitute for the original work. It is possible that a parody, if it is sufficiently biting in nature, could harm the demand for the original, but the court held in that case that this does not produce a harm cognizable under the Copyright Act, which is why when talking about market harm, you're really looking at market substitution. So in that case, the parody song was found to be fair use. Another example, which you might be familiar with, is actually Google image search. There was a case, Perfect 10 v. Google, about whether Google image search infringes on copyrights of rights holders in these pictures from the internet when it creates thumbnails of those pictures for use in Google image search. And the court held that this is a transformative use because Google image search is transforming the pictures into thumbnails, which work as kind of identifiers to help you find websites. The court held that this was a new type of use as well as being socially beneficial, and thus that the purpose and character prong was met. As for market harm, the court also found that thumbnails do not substitute for the full-size images, meaning that the market harm prong was met, and in the end, the court held that Google image search is fair use. So you can thank that court decision for those late nights spent looking up pictures on Google image search to use in PowerPoint presentations. Not like know anything about this.
Thank you, Judge.
Thank you. One question you're probably wondering now is fan work, fan art, fan fiction, things of that nature, is that fair use? And the answer, as lawyers love to say, is maybe. There was a case where there was a Harry Potter reference book made by a fan, which a court did actually find was transformative. However, the court also found that it took too much from the original books, like copying full-on passages, to qualify as fair use. So that's the amount and substantiality piece of the test. One way you can consider managing risk if you are in that position is that many intellectual property holders, such as Cover, Team Shanghai Alice, Games, and so on, publish fan work guidelines, which you can potentially consider using as a way to know how much risk you're getting into if you draw fan art or things of that nature of that property. As an example, Cover's fan art policy for Hololive prohibits things like defamatory commercial use of their intellectual property. Games fan work guidelines for Uma Musume quite infamously prohibits drawing any adult-oriented content of their property. Not that I know anything about this. So that's fair use, and let's talk a bit about works for hire. Because, well, how many people here have commissioned artwork before? Yeah, good number of you. How many people have been commissioned? Okay, yeah, a few of you. And you might be wondering in that situation, well, who owns the copyright? So, typically the copyright, which again, attaches whatever the statutory requisites of original expression or authorship and fixation exist. It exists in the creator. And copyright generally does not transfer to the payer unless, one, they explicitly agreed to do that in contract, or two, the artist was an employee of the payer. And when I say employee, I mean it in the general common law sense of, did the payer control the manner and means of doing the work? Did they provide the tools to get the work done? The workspace? Did they control the hours in which work is done? Did they have the ability to assign additional work? And so on. And the idea of this test is to separate things like a one-off commission from something like an artist who works full-time at a company. One example of that being, does anyone here watch Shirobako? Okay, yeah, there's a few of us. So, in Shirobako, it takes place at an anime studio, and so all of the employees of that studio, any copyrightable subject matter that they produce, as part of their work for that studio, would presumptively belong to their employer. So that's works for hire. Let's talk a bit about licensing. So, we discussed transfer briefly. That's giving over your copyright to someone else. And licensing is a kind of a subsequent lesser form of transfer, where you allow someone to perform some or all of its exclusive rights involved in copyright we discussed. Some examples of licenses that are out there include online production, display, exhibition at an event or on streaming, printing rights, merchandising rights, licenses to do derivative works, and so on. Licenses can also be, depending on how they're written, they can be exclusive, meaning that only the licensee is able to use the intellectual property in that way. They can be non-exclusive. They can be worldwide or in specific parts of the world. They can be perpetual or only for a limited time. One particularly infamous example of a license is Harmony Gold's license to the Super Dimension Fortress Macross intellectual property, which allows Harmony Gold to actually exclusive rights to use Macross everywhere outside of Japan. Incidentally, this license is also the reason why Macross was not seen legally in the West for many, many years, prior to I think 2023. So, can I get a boo for Harmony Gold? Boo! Yeah, that's right. One type of license that I think is particularly relevant, especially for any music types of VTubers out there, is licenses to make a cover of the song. So covers actually have special rules that they're subject to a compulsory license, also known as a mechanical license because it comes from those player pianos that you might have seen in like Fry's stores when you're growing up. I'm sure I just dated myself there. Anyway, the idea is that you can always make a cover of the song. The license is automatic. The original creator of the song can't refuse to allow you to make the cover. However, you do have to pay a licensee which is set by statute at 9.1 cents per download or 9.1 cents per song on physical albums, which you can imagine could add up. There is an exception for audio streaming platforms such as Spotify, and those platforms will cover the fee under the user's behalf, taking without any royalties and whatever else be owed, under the mechanical licensing collective. Importantly though, this doesn't apply to YouTube or other audio video platforms because those need a separate synchronization license. In addition, large copyright collectors such as BMI, ASCAP, CSAC, and so on, those sell blanket licenses for their entire catalog to things like radio stations or restaurants that just need some background music. So let's talk a bit about public domain. And the duration of copyright is the life of the author plus 70 years, or in the case of works for hire or works where the author is unknown or anonymous, it's 95 years from publication or 120 years from creation, whichever is earlier. Works from before 1978 are subject to different rules, but don't really need to get into that. And after a copyright has expired, the work goes into the public domain and is free for anyone to use. And so you might have heard somewhere, if a work is on the internet and publicly available, that means it's public domain and anyone can use it. It is not true. To enter the public domain, the work either has to expire under the terms of the statute or be voluntarily released into public domain. One thing I should point out is that even though a character may be in the public domain, newer works starting them may still be under copyright. This actually gets into some weird situations with characters like, for example, Mickey Mouse or Sherlock Holmes is another character where the original work starring them is in public domain by now because it's been more than 70 years since Arthur Conan Doyle's death. So Holmes himself is in public domain, but the newer stories are still copyrighted, which means that you make a work starring Sherlock Holmes, in theory, you can't use aspects of his character that came from the newer stories. So it's a very weird situation. So we touched on this a bit, but let's talk about copyright abandonment. Now, some of you may have heard copyright owners have to take action against infringers, otherwise they lose their copyright. But the Supreme Court has held that copyright owners have no duty to challenge each and every actionable infringement. Copyright abandonment is a thing, but it's more difficult than you might think. It does require both intent to abandon copyright and an overt act to surrender the copyright, to announce to the world that this is free to use. So inaction alone is typically not enough to establish a copyright abandonment. Trademark is a bit different, But that's something we can discuss in another panel perhaps, just in the interest of time. So, again, because of everything, we do have to discuss AI. And works produced entirely by generative AI are not eligible for copyright. That's a quoting from the Copyright Office. You might be wondering, well, do works produced by AI infringe on the material on which they were originally trained? And once again, the answer, as lawyers love to say, is maybe. There was a recent court decision that held that AI training on books was fair use, but because the company, which rhymes with Banthropic, had pirated the copies of the books that they used to train the AI, that copying was copyright infringement. Then there's another lawsuit in progress now about whether actually that same AI company can be liable for enabling copyright infringement of song lyrics. But the law in this area is developing very fast, so I'm sure this slide will be outdated in a year or even a few months from now. So, now that you know everything about copyright, do a quick quiz. Let's say you're starting a food trip with your friend, and your friend wants to use a picture of Watame from Hololive to advertise a truck. You ask your friend if they have permission to use the picture, and they say that they downloaded it from the internet, meaning it's public domain. Is your friend correct?
No.
No, they are not. Copyrighted works do not become public domain simply because they are available online. Copyright abandonment only exists if the owner both intends to surrender the copyright and takes overt action to do so. And finally, as we discussed, covers bandwidth policy prohibits commercial use of the Hololive IP. So let's talk a bit about contracts now. We're going to talk about things like contract formation, terms not in the contract, some common contract terms you might see around, things like arbitration clauses, NDAs, non-competes. So to form a contract, you need to have offer and acceptance, otherwise known as a meeting of the minds, meaning did both parties intend to form a binding legal relationship? And what it means, interestingly, is those terms of use that you scroll through without reading, and you click every time you want to install a new game or whatever. Those actually are generally enforceable. They're called click wrap agreements. It does kind of depend on the facts. Things like browse wrap agreements, which is when it says on the bottom of the web page in tiny font, by using this site you agree to these terms linked somewhere else that you may or may not have read. Those are actually generally not enforceable contracts, but the click wrap is, so it's very fact dependent. Second, there has to be definite terms. The subject matter, contract, parties, and so on have to be defined clearly enough for a reviewing court to know if there's been a breach of the contract or not. Third is consideration, meaning when anything of value is changed. Money, promises to perform things like that. And for the purpose of consideration, the court doesn't look at whether something is a good deal or not, as long as consideration isn't clearly so minor, so trivial that it's really a gift kind of arrangement, because gratuitous agreements, agreements to do something for no or completely trivial value are not enforceable contracts. Fourth is competency. Do both parties have capacity to contract, meaning things like they're not a minor, they're not impaired, insane, things of that nature? Or in the case of contracts with companies, did the employee entering the contract for the company actually have authority from the company to do so? And finally, is legality. You cannot contract to do something illegal. However, I should note that a lot of contracts contain severability clauses, meaning that if some part of the contract is legal, it continues to force in effect without the illegal pieces. One thing I do want to note is that contracts do not necessarily need to be in writing. Oral contracts are a thing unless the statute of frauds requires a writing, and that can happen if, for example, the contract is intended to run longer than a year. Most lawyers would not advise you to rely on oral contracts for obvious reasons. What happens if, something is left out of a contract? Well, most courts will not read language into contracts that was not intended by the parties, and in fact, most contracts have what is called a merger clause. This agreement constitutes the entire agreement between the parties, and that's just a long way of saying that nothing outside of the contract binds the parties. What that means is if you're negotiating a contract and the person says in an email or whatever that they'll do X, and X doesn't end up in the final contract, that would not be binding on the parties. One exception is that in some cases, courts can consider the context of the relationship between the parties, industry practice, and so on, as aids to interpretation of contracts, although specific contract rules do vary widely state by state, so that's something that really requires a consultation with a lawyer. Now, one thing that contracts will usually specify is the scope of work. They should be specific about what work is and is not included, particularly if you're in a situation where someone is charged by the hour or by the piece. Contracts typically address changes to the work, what kind of changes to work can be requested, what the changes add time or money and how much. And then if contract requires additional documents like a report, a sketch, certain legally required contract provisions that mostly comes up in federal assistance contracts. But things of that nature, contracts will usually incorporate any necessary additional documents by reference, and there will be something in the contract stating that the parties' agreement includes all of these together. Now for the fun part, money. There are all kinds of payment models that contracts can use: fixed price, milestones, hourly or daily rates, percentages, reimbursables per click, cost plus, and so on. And for those payment structures that are variable, like hourly or percentage, contracts typically include a minimum and or a maximum not to exceed amount. If the contract does have a contractual maximum or not to exceed, the contract may require that a party provide notice before doing any work that would cause the cap to be hit. And that allows parties to amend the contract and increase the cap before that extra work happens. I actually have been in this situation where this was an expert witness contract, and they were charging hourly and had a not to exceed contractual maximum, and they just went over the max without realizing it, and we were not able to pay back the hours that went over the cap because, at the time we had agreed to a maximum not to exceed amount. If the party had brought it up with me before we hit the cap, I probably would have just agreed to increase the contractual maximum, but with the contract the way it was, we weren't able to pay out the extra work, and it would have been a gratuitous gift of money and would have caused some audit issues. In addition, when talking about contract payment, things like commercial use or transfer of intellectual property, if something is contracted to do creative work, those do, of course, have an effect on the price. Another thing I should mention is that contracts usually don't allow work to be paid until it's done before the contract becoming effective. For this reason, when I'm entering into contracts, I never authorize or allow, let alone direct anyone to do any work before the contract has been signed, executed by both parties. And the reason for that is if someone has done work without having an executed contract in place, you can potentially get into what is called quasi-contract situation where a court tries to piece out, would it be a fair amount to pay for the work, and just gets messy and is something that I prefer to avoid. Now, timing. Let's say that you're doing a real basic commission. Here's $100 to draw a picture of X and it's with a friend, and you don't really care as much about it, but typically if you're at the stage where you're entering into a formal written contract. It should be specific about what must be delivered by when. As an example, if someone is commissioning art or something that's time sensitive, such as an event, some birthday or so on, you should really be setting a specific delivery date, and that date should have some float built into it so that the delivery date falls well before the thing is needed. And because you don't want to be in a situation where you promised to do this by at some point, and then it's a year later, and people are wondering, like, when is this actually going to happen? Typically, it's best practice to set some date certain, and you can always get together and change it later, but it is good to have that certainty up front. Contract deadlines, of course, can be changed later by mutual consent to amend the contract, or the contract may actually have extension of time provisions written into it. This is more common in things like construction contracts, or say the house painting contract. Maybe it allows the deadline to be pushed back for bad weather, which makes sense. Contracts should also have terms around the timing of invoices, especially if payment is going to occur more than once. The contract should specify when and how often invoices should be submitted, any kind of approval process will be required before the invoice is paid out, how long this party have to pay received invoices, and things like that. And contracts should also address disputes, because you want to know what's going to happen if parties disagree before the disagreement happens, so that you have an orderly process for resolving this disagreement, and not, say, people writing Google Docs at each other over Twitter. So dispute clauses in contracts may include automatic dispute resolution. Maybe you've heard somewhere about arbitration clauses. Those are very common and typically are enforced, though some exceptions exist. Arbitration just means that the parties get together and they hire an arbitrator, which is kind of like a private judge. Tell us something that's like a trial, but not quite. The arbitrator's decision is binding on the parties and almost always final. It is possible in theory to overturn an arbitrator's decision in court, but it's very uncommon and usually only happens if the arbitrator has made a clear error of law or gone completely outside the authority by the parties set out in arbitration laws. There is also mediation, which I was just at one of these earlier this week. But mediation is where the parties hire a neutral third party, typically like a retired judge or something like that, to try to help the parties come to a negotiated settlement. They'll go to one side and try to talk them down, go to the other side and try to talk them up. But the important thing about mediation, and the thing that separates it from other forms of argument dispute resolution, is that mediation is not binding. A mediator can try to convince the parties to resolve the matter, but cannot order or direct the parties to agree to anything. So mediation is only really effective if both parties are going into it with a good faith interest in trying to settle whatever case it is. Contracts also typically include venue and enforcement law provisions. That just means if there is a lawsuit brought to enforce a contract, where is the lawsuit going to be brought, what laws are going to apply. And this is especially important when it comes to international contracts, because obviously the party who's bringing the lawsuit in their home state may have an advantage. Now, some other contractual clauses you might have seen somewhere include non-disclosure agreements. That's a contract not to disclose certain types of information. Or non-compete agreements. That's an agreement not to work in a certain field, in a certain geographic area for a certain time. And the enforceability of these types of clauses does vary by jurisdiction. As an example, California does not recognize most non-competes. There are some pretty limited exceptions. And when you're looking at the NDA or non-compete, general contract defenses such as unconscionability, meaning that in terms of the contract, either the substance or the way it was reached are completely unfair. The court may refuse to enforce it, or voidness against public policy. Things of that nature may apply, but it does require checking with a local attorney. One thing I will point out is that the rule against illegal contracts still applies to NDAs and non-competes. So, for example, NDAs cannot override statutory whistleblower protections because parties cannot agree to something that is illegal. So, that is contracts, and you have another quiz. So, you and your friend are drinking and complaining about your boss, and your friend is really wasted, and they say they'll kill your boss for you. Is this an enforceable contract?
Yes.
No, unfortunately, it is not. One, if your friend is drunk, they do not have capacity to enter into a contract. Two, there's no consideration because there's no return promise in exchange for the promise to kill your boss. And third, murder is illegal, and you can't contract to do something illegal. So, now that you know everything clearly about law, you might be wondering, when do you need to go out and get a lawyer? And those situations would include, but are not limited to, if you're suing, or definitely if you're being sued, if you're drafting or reviewing contracts, if you're trying to form a corporation or have other regulatory filings to do, if you're making decisions that involve a lot of risk or possible liability, definitely if the other party has a lawyer. I have a friend once who said that lawyers are kind of like snipers in video games. If neither side has one, maybe you're okay. But if the other side has one, you definitely also want one. And finally, you should consider retaining a lawyer anytime you'll be more comfortable with it. Okay, so you need a lawyer. Should you rely on the other side's lawyer? The answer is no, because the other party's lawyer has no duty to represent your interests. And if they're following the ethics rules, they should tell you as much. But every state which I'm aware, their bar association has a referral service that people can use to look up lawyers in the area. Depending on where you are, a law school or a local bar association may have a pro bono, that is a free legal services clinic, though those are typically means tested. You have to be making below a certain income. I will also note that these clinics typically specialize in doing things like family law or landlord-tenant law, because those are the types of issues that people making that low income usually have. You can consider organizations like Volunteer Lawyers for the Arts. They're an organization that sets up a lot of, it's in the name, volunteer legal services for artists who do really good work. And finally, if you have used a lawyer for something else, you can ask if they know any lawyers who are working in the relevant specialty. But of course, you're probably wondering, well, how much does this all cost? And unfortunately, I do have to let you know that some lawyers do charge a fee for consultation, others don't, but that fee is to compensate the attorney for the time needed for the consultation, plus any conflict checks, because just consulting with a lawyer can implicate conflict of interest.
Well, I was saying, he's retired now.
And attorney rates do vary quite a lot based on the experience of the lawyer, their specialty, the location, but it can be somewhere between like $250 to over $1,000 an hour. Obviously, that is a lot of money. But depending on the type of case it is, some lawyers take cases on contingency, meaning they take a percentage of whatever recovery you may or may not end up getting, or they may take cases if there's a possibility to get attorney's fees from the other side. And you should know, because you are in a position of paying out this huge amount of money per hour, that clients have the right to review attorney billings and make sure that all of the costs and so on are reasonable. But wait, instead of going to all this time and expense, can't I just use AI for my legal needs? And the answer is no, for a variety of reasons. Which is that generative AI consistently makes things up, including legal cases, and this can and has, in many circumstances, gotten lawyers in a lot of trouble with courts, because there is an ethical rule about candor to the tribunal. Seriously, I Googled lawyer-sanctioned AI use, and these are just three of the many, many examples that came up. It is truly shocking. So, yeah, definitely be careful about relying on AI for anything, but especially for legal questions. So, we have about 15 minutes left, and we have some time to take questions, but again, because I am a lawyer who is not your lawyer, I cannot provide legal advice in this forum, so please keep your questions general. Yes.
I'm gonna go with Mike.
Yeah,
All right.
that'd be great.
I have a question about survival clauses, if that's all right.
Yes.
So recently there've been a lot of high-profile, this is specifically in the context of VTubers, a lot of high-profile VTuber organizations
I'm
that
aware.
have gone under, as I'm sure you're aware. Just context for the audience. In the cases of organizations where there may or may not have been some kind of impropriety, whether it's legal or just purely ethical, how survivable are the clauses in the contract against, for example, disparagement clauses or non-disclosure agreements for the talents after the organization is dissolved? Can the individual members of those agencies go after those talents after the organization goes away?
That's a very interesting question. So this hypothetical VTuber company, its successors in interest would actually be like whoever the assets of the corporation end up being parceled out to in the bankruptcy, because it is something that is hypothetical company is going through now. The assets of the corporation will be given out to whatever creditors would be given to, well, the company, if there is a receiver, the corporate receiver would have control of those assets, which I suppose the right to enforce a non-disparagement clause is technically an asset, so perhaps whatever court-appointed receiver or successor in interest might, in theory, be able to enforce that non-disparagement clause on behalf of the former corporation. I think, speaking practically though, I don't think that's something that would be of very much value, because, if you think about it realistically, what value is a non-disparagement clause for a purely hypothetical corporation whose reputation is already in the shitter?
Right. Thank you.
Yes, if you come up to the mic.
Hi, sorry, I came late to the panel,
Oh, no
so
worries.
I'm not sure if you already covered this topic, but yeah, I was just curious. I wanted to ask about just like protective clauses, like for example, the character clause. Like, would you mind elaborating more about these sort of like protective clauses in case like something happens and incident happens or something? Is there just a way for you and your party to protect yourselves if the other party gets involved in something, does something, etc.?
So you might be thinking about things like indemnification clauses, which is a way of shifting risk from one party to another. So in a contract, you might have language like one side agrees to protect and indemnify the other side for any negligence that the party might have committed. So those are typically mutual, and typically, I know in my state, other states might be different, but typically you can't be required to indemnify a party for their own negligence, only for the consequences of your own negligence. But it is one actually pretty common way for parties to protect themselves. Basically, if one party to an agreement does something to incur liability for one or both sides, then they're responsible for the consequences of their own actions. They're responsible for defending that claim. And these kinds of clauses are typically drafted by lawyers in consultation with insurance companies, because the insurer will usually pick up this kind of defense. Does that answer your question?
Yeah, it does. Thank you.
Sure thing. Yeah, if you could come up to the mic.
I think this will be pretty relevant to a lot of consolers.
Yes.
I'm not sure if this is in regards to fair use.
Yes.
Does costumes or cosplaying count as fair use, or is that again maybe case by case kind of refers to the guidelines?
Well, that's an interesting one. And the reason for that is that costumes, clothing are in a kind of a weird spot when it comes to copyright, because again, copyright covers original expressions. And of course, clothing is a way of expressing yourself, right? How you choose to dress yourself says something about you. However, clothing is also a useful object, like it's an object used to cover your body and things of that nature. So clothing is already in a weird place when it comes to copyright. However, I am aware of cases where certain corporations that run with Disney have served cease and desist on people cosplaying their characters. Usually, this is like if a person is doing it to make money, like they're asking for $5 to take a picture with Spider-Man or something like that. But it is something I'm aware is going on. I think that whether a given case of cosplay qualifies as fair use is a really fact-dependent question now. Yes, if you could come up to the mic.
Yeah. I got two questions.
Yeah, of course.
First one is, let's say I stole something. I'm practice. I'm not, what should I do? It's hypothetical.
Purely hypothetically.
Yeah. The second question is, you do commissions, and when you do commissions, do you do your own contracts for the commissions, or do you just have like a template you use from someone else?
Okay, so to answer the first question, if you stole something, you should definitely be speaking with a lawyer, preferably a criminal defense lawyer. The second, I don't really do commissions, really keep my illustration work as a hobby, but I am aware of some artists and not necessarily lawyers either who do have specific terms that they request. I think what's more common is that through platforms like, say, Skeb or so on, they do have form terms that apply globally to commissions through the platform.
Is your platform like that?
I mean, it is a possibility. If someone has, like, say, some kind of special extraordinary requirements, for example, they are looking for a great level of control than Skep allows, which is no control, then potentially it can make sense to use like a bespoke contract.
Gotcha.
Yeah, if you just come up to the mic.
So I manage contracts in
Yeah.
some form or another, but I'm very new to this.
Yeah.
Do you have any tips for kind of understanding some of the contractual languages within those, understanding the clauses, and just kind of memorizing them in the case of having hundreds of clauses?
Well, I will tell you, what helps in that respect is that a lot of contracts, you guys would be surprised how much of those contracts see out there just copy and paste it from somewhere. Like, a lot of the time parties will just agree to X or Y term because, well, it's standard in the market. And what does standard in the market mean? It means that somebody at a law firm that does a lot of these types of contracts just copy and pasted the same clause over some number of years. And honestly, the clause may only change because a new court decision came out that made that clause unenforceable or unacceptably risky, things of that nature. But if you do have a job managing contracts, I think what's helpful is to, honestly, to just speak to people who administer contracts and look at ways in which contracts have actually been applied in the past. Any court cases, any legal battles that have occurred over the contract. But because a lot of it is so formulaic, I think it is something that one can really get used to and memorize some of the more common terms. Is that helpful?
Yeah, thank you.
Yeah, if you would come up to the mic.
How binding / enforceable are fan work policies? If a company says these specific things are okay, do they have the ability to change their mind and go after people who made work under those policies? And also, like, on the opposite end of the spectrum, if they say these specific things aren't okay, do they have, you said there wasn't any obligation to defend copyright, but like, are you in more hot water than you would be violating copyright, just broadly speaking?
Interesting question. So, if a company has previously stated that these kinds of fan works are acceptable, I think there would be definitely a compelling legal argument that there is stopped, and that's a legal term meaning that it will be unjust to allow the party to bring a copyright action they previously stated that that kind of use will be okay. I think that would be a good defense, but I'm not personally aware of any cases in which that's actually been tried. So that's definitely, I mean, there is some risk there. I think I would feel pretty good about that kind of defense, but I can't say for certain. As to the other part of your question, just to make sure that I understand the question correctly, you're asking if a company has previously stated that some types of fan works are acceptable, then would they be, I guess then, would they be prevented from enforcing against things that aren't in the fan work policy?
To use the example you gave previously of Psy Games, if Psy Games went after people who violated that fan policy, do they have a stronger case than if another company, IP holder like Disney, went after people for a similar case?
I see. So you're asking if the existence of the fan work policy, I mean, has any bearing on whether they can enforce generally?
Yeah.
Okay. That's an interesting question. Honestly, I think it would be pretty fact dependent, but I mean, the fact, again, this is Supreme Court precedent that rights holders generally have the right to decide when and where and against who they enforce their copyright. So I don't think it would have a terribly large effect.
All right, cool, thanks.
Yeah, sure thing. Anyone else? Okay, well, if there are no other questions, here's a list of the sources that I used, and this PowerPoint will be uploaded on my socials. You can find by scanning the QR code, and you can follow me on Twitter or Blue Sky or any of the social media garbage. If you want to see some of my art or commentary or really bad posts. Actually, it's mostly bad posts. I don't really, can't really in good conscience recommend you follow me, but there it is if you need it. I have cards up here as well as badge ribbons. If there's nothing else, then thank you all for coming and enjoy the rest of your con.